Court calls the case, People versus Mercedes Brewer.
This courtroom session starts off like many others, routine, procedural, almost predictable. But don't let that calm surface fool you. What you're about to witness is a series of decisions that quietly reveal how the justice system balances accountability, financial reality, and second chances. Judge Entity People. Judge Simpson, Michigan court judge, steps into a lineup of defendants, each with different circumstances, but all facing the same underlying question. How much responsibility is enough? And what happens when someone simply can't afford to comply? From fines and probation terms to strict behavioral conditions, every word spoken here carries weight. And pay attention, because the tension in this courtroom doesn't come from shouting or chaos. It comes from subtle moments. A hesitation before answering. A financial struggle exposed in real time. A judge deciding whether someone deserves leniency or consequences. You'll see people trying to negotiate their reality with the court. Some honest, some struggling, some already on thin ice. And here's the twist. Not all consequences are equal. Some walk away with structured chances to recover, while others face immediate punishment when prior behavior catches up with them. So watch closely. Who's truly being held accountable and who's barely holding it together under pressure.
Assistant Public Defender Calvin Hawthorne appearing with and on behalf of Mercedes Brewer. Ms. Brewer, please state your name.
She here?
Mercedes Brewer.
All right. Ma'am, could you turn on your camera, please?
Sorry, yeah, I don't know what's. I apologize. Okay.
All right, there you are. All right. Okay, go ahead, Mr. Hawthorne. This date and time set for sentencing.
Your Honor, we did have a chance to review the recommendations that were sent over by Ms. Pilara. Ms. Brewer has no objections or material changes, so we're asking the court to follow the recommendations.
All right. And Ms. Brewer, is there anything you'd like to tell the court before I do impose sentence?
No.
All right. It is the sentence of the court. I'll place you on 4 months prosecutor deferred sentence. You are to pay $555 fines and court costs, $120 probation, oversight fees. When can you pay that, man?
I can pay some today, not the whole thing, but.
This moment may seem small, but it's actually one of the most revealing parts of the entire hearing. The court isn't just handing out punishment, it's negotiating compliance in real time. When Mercedes Brewer says she can only pay a portion today, what you're seeing is the system confronting financial reality head-on. Judge Simpson doesn't immediately push back aggressively. Instead, he asks a key question: define some. That's not just curiosity, it's control. Courts need specificity because vague promises don't translate into enforceable compliance. By locking her into a $100 payment today and setting a structured deadline, the judge is creating accountability without shutting the door on her situation. But here's the bigger issue. Should financial penalties be structured this way? If someone genuinely can't pay immediately, does extending deadlines solve the problem or just delay the pressure? And think about this. Would you prioritize paying court fines if you were living paycheck to paycheck, or would survival come first?
Okay. All right. Define some for me. How much can you pay?
I could do like 100 today.
All right. I'll say $100 today. And then how are you going to pay the balance?
I'm gonna pay more on it when I get paid next week. So I can pay more next week.
Okay. All right.
I'm gonna try to get it all paid within the next like week or two for sure.
Oh, okay. So if I say the balance by the end of August, will that work for you?
Yeah, or can we maybe do the beginning of September?
Okay. Why don't we say balance due by September 15th?
Okay, that'll work. That'll be perfect.
All right. Balance due by September 15th, 2023. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. Okay. You are to complete a theft class. You're to do that within the next 60 days. You are to complete 25 hours of community service with proof to probation. You're not to go to any Walmart store in the state of Michigan. You are to submit your fingerprints with proof to probation.
Now this is where things get interesting. That restriction, banning someone from entering every Walmart in the state, might sound extreme at first, but it's actually very targeted. It tells you exactly what kind of offense likely occurred. Retail theft or misconduct tied to that specific environment. This isn't just punishment, it's prevention. Courts often impose location-based restrictions to eliminate temptation and reduce the chance of repeat offenses. It's a behavioral correction strategy disguised as a legal condition. But here's the question. Does banning someone from a major retail chain actually change behavior, or does it just shift the problem somewhere else? Also notice how quickly these conditions stack up. Fines, probation fees, drug restrictions, community service, classes, and now restricted locations. Individually, they seem manageable. Together, they create a system where one slip-up could trigger serious consequences. Is this structured discipline, or a setup where failure becomes almost inevitable?
I'll set a review hearing that is to be held December 13th, 2023, 9 a.m. I'll order 365 days in jail. That is suspended. All right.
All right.
Thank you, Ms. Brewer.
Have a good day.
You do the same. Court calls the cases of the people versus Dominic, Kelley-Payne.
Good morning, Your Honor. Silvana Reed, Assistant Public Defender, with and on behalf of Mr. Kelley-Payne. Could you please unmute and state your name, sir? You're still muted.
Dominic Kelley-Payne.
Thank you. And did you have a chance to review the documents that I sent to you?
Yes.
Do you have any corrections that needed to be made?
No.
Your Honor, given this is sentencing, we have no additions, deletions, or corrections, and would just ask that probation's recommendation be adopted.
Sir, is there anything you'd like to tell the court before I do impose sentence?
Yeah, I'm like extremely low income. Like I just got a job working at Windsor Mode, and I'm able to pay my fines and court fees. But I'm like extremely low income, so I can't like pay any money right now.
This is one of the most critical moments in the entire session. The defendant openly admits financial hardship, and not just casually. He emphasizes being extremely low income, which immediately shifts the dynamic in the courtroom. But here's where it gets complicated. The court acknowledges the situation, but doesn't remove the obligation. Instead, the system adjusts around it. Payment plans, probation oversight, structured timelines, it all sounds reasonable on paper. But in reality, it still places pressure on someone who just admitted they have no immediate means to comply. And then there's the underlying tension. The judge is balancing empathy with responsibility. If courts simply waived financial penalties every time someone claimed hardship, the system would lose enforcement power. But at the same time, I'm pushing too hard risks setting people up to fail. So where's the line? If someone genuinely has no money, should punishment shift away from fines entirely? Or does accountability require financial consequence no matter what?
All right. Understood. But we also have an issue with regard to your community corrections, which is taken into account in terms of the sentencing for his positive test for THC and cocaine.
Okay.
All right. So, let's do it this way. And you went over that with him, Ms. Reed?
I went over the PSI reports. I did not go over if there was a bond violation.
Well, it's been taken into account. He had a positive test for THC and cocaine on June 23rd, and then failed to test after June 23rd. So I'm taking that into account on his sentencing, but I want to make sure everybody's had a discussion about that.
We did not have a discussion about that.
All right. Well, he's seen the recommendation, so.
Yes, he has seen that.
Yes, I have.
All right. On case ending in 713, it is the sentence of the court. I'm going to place you on 12-month deferred sentence pursuant to the prosecutor deferred sentence program. You are to pay $480 fines and court costs. That's to be paid as directed by probation.
Okay.
I'll waive any probation oversight fees on that case. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as directed by probation. You are to complete a theft class. You're to do that within the next 60 days. You are to complete 25 hours of community service with verification to probation. You're not to go to any Meijer store in the state of Michigan. I'll set a review hearing. That's to be held August 14th, 2024 at 9 a.m. I'll order 90 days in jail, credit 33. Balance is suspended on that case. On the other matter, that case ending in 366, on count one, the receipt and concealment of stolen property, I'm going to order probation for 18 months. You're to pay $555 fines and court costs, $540 probation oversight fees. That's to be paid as directed by probation. There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as directed by probation. You are to continue your random weekly drug testing at community corrections. You understand that?
Yeah, I understand, but I'm just not able to pay the money.
You need to talk to probation about that, but you're to continue your testing. You somehow or another found money to pay for the cocaine you had. So I think you can find the money if you want it.
This is the turning point, and the tone shifts immediately. Up until now, the courtroom has been relatively balanced, even accommodating. But here, Judge Simpson draws a hard line. That statement isn't just criticism, it's a direct challenge to the defendant's credibility. The judge is essentially saying, you claim financial hardship, yet you were able to fund illegal activity. So the issue isn't just about money, it's about priorities. And this is where courtroom psychology comes into play. Judges don't just evaluate facts, they evaluate behavior patterns. This comment signals that the court no longer sees the defendant as someone struggling, but as someone making questionable choices. From this point forward, leniency becomes limited. And think about it, does that argument hold up? If someone spends money irresponsibly, does that justify stricter punishment later? Or should financial instability still be treated separately from past mistakes?
You are to complete the CCOP program. You're to continue with mental health services at Washington County CMH. Follow all treatment recommendations, including medication protocol with status reports to probation. I will order 365 days in jail, credit 31 days served. You are then to report to the Washington County Jail to serve an additional 5 days. You're to report by 6 p.m. this evening, and then the balance of that sentence will be suspended. Failure to report will result in a bench warrant for your arrest with no bond. On count two, the controlled
So
substance
I got to turn
charge.
myself in. I'm sorry. So I had to turn myself in and do 5 days.
Yes, sir. You need to do that by 6 p.m. today. On the controlled substance charge, 18 months probation, $555 fines and court costs. That's to be paid on a payment plan as directed by probation. You're to comply with all terms as set forth in count one. I'll order on that count 365 days in jail, credit 31. Defendant is remanded to serve an additional 5 days in jail due to the bond violations. He is to report to the Washington County Jail by 6 p.m. today, and then the balance of his sentence will be suspended. Failure to report will result in a bench warrant with no bond. Thank you.
Thank you, Your Honor.
You need to track that. Okay.
So is
Or
that
that's
10
not the case.
days? I'm
Pardon?
sorry. Is that 10
No, it's
days
okay.
or is that 5
No,
days?
it's just if you get over there and get yourself in, it's just going to be 5.
There's a subtle but important psychological moment here. The defendant asks if it's 10 days, almost bracing for something worse. And when the judge confirms it's only 5, you can feel the shift. Relief, even in punishment. That's not accidental. Judges often frame sentences this way to reinforce perspective. By emphasizing that the outcome could have been harsher, the court positions the punishment as measured, even fair. But here's the deeper layer. This also reinforces authority. The message is clear. Your situation could escalate quickly if compliance doesn't follow. And notice how the defendant responds. Appreciation. That's a powerful shift. Moments ago, he was resisting financially. Now, he's acknowledging the court's decision. So ask yourself, does framing punishment as lenient actually make people more likely to comply? Or does it simply make the system feel more controlled while the underlying issues remain unchanged?
Okay.
Okay, I gave you the minimal amount because we got to get you straight.
All right, I understand. I appreciate that, Your Honor.
All right, take care.
Yep, you too.
Court calls the case, People versus Rajah McCrainy.
Silvana Reed, Assistant Public Defender with and on behalf of Rajah McCrainy. Could you please unmute and state your name for the record?
Rajah McCrainy. Oh, there she is.
Hi, Rachel McCrainy.
All right.
Did you have a chance to review the documents I sent you?
Yes, I did.
Do you have any corrections that needed to be made?
No.
Your Honor, there are no additions, deletions, or corrections to the PSI report, and we would just ask that probation's recommendation be adopted.
McCrainy, anything you want to say before the court imposes sentence?
No.
Sentence of the court, $555 fines and court costs. Will apply the bond, which is $450. Can you pay the remaining balance today?
I'll get paid on Friday. I can pay it as soon as Friday, the remaining balance.
Okay, so what I'll do is I'll give you till Monday to pay it. So pay it by the 14th. Okay.
This is a completely different tone compared to earlier cases. Here, the judge shows flexibility, but it's structured flexibility. The defendant asks for time until Friday, and the judge extends it to Monday. That might seem minor, but it reflects a consistent pattern. The court is willing to work with people who present clear, short-term plans. What matters here is confidence and clarity. The defendant didn't say, "I'll try." They gave a specific timeline, and the court responded with a manageable adjustment. This is where courtroom outcomes often hinge on communication. Two defendants may have similar financial struggles, but the one who presents a concrete plan tends to receive more flexibility. But here's the key question. Is the system rewarding honesty and planning, or just favoring those who communicate better under pressure? Because not everyone can articulate their situation clearly in a courtroom setting.
Make sure you can get it here.
I will.
All right, and then I'll order 365 days in jail. Credit 6 days served. The balance is suspended. All right. Thank you, ma'am.
Thank you.
Court calls the case. People versus, is it Sine Miller? They wrote it.
Silvana Reed, Assistant Public Defender with and on behalf of Jana Miller.
Yes, they wrote it in my file.
Could you please unmute and state your name, ma'am?
Jana Miller.
Your Honor, today is for
I
sentencing.
apologize, Miss Miller, about messing up your name. Go ahead, Miss Reed.
We have no additions, deletions, or corrections and would ask that probation's recommendation be adopted.
Miss Janae Miller, is there anything you'd like to say before I impose sentence?
No.
All right. Send to the court. I'm going to place you on 4 months prosecutor deferred sentence. You're to pay $425 fines and court costs, $120 probation oversight fees. When can you pay that, ma'am?
Not today. Probably sometime next week.
You can get it all paid next week, you think?
Not all paid next week.
Okay, so what are you telling me? Oh, she froze. What did you say, ma'am?
Is there any way I can get on a payment plan?
Well, what can you pay next week?
Probably 100 to 150.
Okay, I'm going to say 100 next week by the, what is that? The 18th.
Okay.
And then the balance on a payment plan as directed by probation.
Now we're seeing the system default to its most common solution, the payment plan. When immediate payment isn't possible, responsibility doesn't disappear. It gets redistributed over time. But here's the catch. Payment plans sound manageable, but they come with long-term pressure. Monthly obligations, probation check-ins, compliance tracking. This isn't just about paying money. It's about staying consistently aligned with court expectations. And remember, these conditions stack with everything else. Drug testing, classes, community service. Missing one requirement can trigger consequences across the board. So the real question is, are payment plans a solution or just a slower path to potential failure? Because if someone is already struggling financially, extending the timeline doesn't always reduce the burden, it just prolongs it.
Okay.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete the behavior modification class. You're to do that within 60 days. You're to complete 25 hours of community service with proof to probation. There is to be no assaultive, threatening, or intimidating behavior by you. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll set a review hearing on this matter for December 13th, 2023 at 9 a.m. I will order 90 days in jail. Credit 1, the balance is suspended. All right. Thank you.
Thank you.
Court does call the case of the people versus, I wrote this one too, Pamela Miller.
Assistant Public Defender Calvin Hawthorne appearing with and on behalf of Pamela Miller. Ms. Miller, please state your name.
My name is Pamela Faye Miller.
Thank you. I'm unsure if Ms. Miller has had a chance to review the documents just because we do not have a direct line of communication to contact her. However, having worked with Ms. Miller on this case, and she's aware that she received the prosecutor's deferred sentence, I do not believe that there would be any objections to the recommendations from probation.
Ms. Miller, is there anything you want to say before the court does impose sentence?
Sir, I'm more than sorry. Like, for real, more than sorry. This is not my kind of adrenaline.
This is one of the most human moments in the entire hearing. No legal argument, no negotiation, just raw emotion. The defendant isn't trying to justify anything. They're expressing regret, and courts do take that into account, but not in the way most people think. Apologies alone don't change outcomes. What matters is whether the apology aligns with behavior and future compliance. Judge Simpson acknowledges it, but still imposes structured conditions. That balance is critical. The court can recognize remorse without reducing accountability. But here's something to consider. How much weight should emotion carry in sentencing? If someone genuinely regrets their actions, should that influence the outcome more heavily? Or should the system remain strictly based on actions and evidence? Because in moments like this, the line between justice and empathy becomes very thin.
Okay. All right. Sentence of the court. 4 months prosecutor deferred sentence. You are to pay $555 fines and court costs, $120 probation oversight fees. When can you get that paid, ma'am?
Sir, I got $300 today.
All right. So you can pay $300 today.
Yes, sir.
And then how will you pay off the balance?
I will try and have it by September, the first week of September, the balance.
Okay, I'll put here balance by September 15th,
No doubt.
2023.
Yes, sir.
There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service with proof to probation. There's no going to any Walmart store in the state of Michigan. I'll set a review hearing that is to be held December 13th, 2023 at 9 a.m. I'll order 365 days in jail. That is suspended. All right. Thank you, ma'am. I think you're at the court. So if you wait a few moments, the file will be down there. You can go out and pay the $300.
I was wondering where I paid. Okay, thank you. Have a wonderful
welcome.
week.
All right. Take care.
Thank you.
Court calls the case of the people versus LaDana Robinson.
Assistant Public Defender Calvin Hawthorne appearing with and on behalf of LaDana Robinson. Ms. Robinson, please unmute and state your name.
Here. We do not have her checked in, Mr. Hawthorne. LaDana Robinson.
I spoke to Miss Robinson this morning. I did send her the Zoom link. This
Oh,
may be
hold on.
her.
She might be here. Miss Robinson, is that you? Wave your hand if that's you, because you're not connected. Okay. She's not connected to audio. I don't know if you have a phone number for her where you can reach her. I'll pass the matter because she got a bench warrant the last time because she didn't show up. So she's here, but she's got to connect herself to audio.
Okay, I'll give her a call right now.
All right, court will pass that matter. Court does call the case. People versus Christina Van Hus.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Van Hus. Could you please unmute and state your name for the record, ma'am?
Christina Van Hus.
Thank you.
There's
And you had a chance to review the documents I sent?
Yes, I have.
Do you have any corrections that need to be made?
I do not.
Your Honor, we would just ask that probation's recommendation be adopted, given that there are no additions, deletions, or corrections to the PSI report.
all right. Very good. Ms. Van Hus, is there anything you want to tell me before I impose sentence?
Yes, Your Honor, I thank you for taking this time out with me, and I do like to apologize for imposing on the court today with my behavior. And it was definitely a mistake on my end, but I have learned and I am ready to take responsibility for my actions.
Let's give you a shot. We all make mistakes in life, right?
Thank you.
We're going to place you on prosecutor deferred sentence for a period of 4 months. You're to pay $555 fines and court costs, $120 probation oversight fees. When can you get that paid, ma'am?
I can make 3 payments bi-weekly. The first payment commencing on the 11th, which is this Friday, the second payment, the 25th, and the third payment, the 8th of September.
Right. And so you're going to pay 1/3 at that point, 1/3 and 1/3. Is that how you're going to do it?
Correct.
All right. Let me see how I'm going to write this. She had that all planned out. All right.
Your Honor, divided by 3, it is 225.
Thank you. Thank you, Ms. Valera. I was waiting for my other mathematician in the courtroom to help me, but she said nothing. No, hey, just okay, Ann. Jeez. Just all right, 225, 3 payments beginning what did you say, the 11th?
Yes.
The 11th, 25th, and 8th. Got it.
This is one of the most organized responses we've seen so far, and it completely changes the tone of the interaction. The defendant comes in prepared with a clear, structured plan, 3 payments, specific dates, exact amounts. And look at how the courtroom reacts. The judge even engages with the math, confirms the breakdown, and finalizes it smoothly. There's no resistance here, just alignment. This highlights a major pattern in courtroom behavior. Preparation equals leverage. When a defendant demonstrates planning and responsibility up front, the court is far more likely to cooperate. It's not about avoiding consequences. It's about controlling how those consequences are applied. But here's the question. Does this create an uneven playing field? Because those who are organized and confident can navigate the system more effectively, while others, even in similar situations, may struggle simply because they're unprepared or overwhelmed. So is justice purely about fairness, or also about who presents themselves better in the moment?
She had that all together. She's going to make it. And she'll be good. There'll be no use of any alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service with proof to probation. No going to any Walmart store in the state of Michigan. You are to submit fingerprints with proof to probation. I'll set a review hearing that will be held December 13th, 2023 at 9 a.m. I'll order 365 days in jail that is suspended. All right.
Thank you, Your
Okay,
Honor. Have a great rest of the week.
Thank you, Ms. Van Hus. You have a great day.
Thank you.
Court calls the case. People versus Kevin Varner.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Varner. Could you please state your name for the record, sir?
Kevin Varner.
And did you have a chance to review the documents I sent?
Yes.
Do you have any corrections that need to be made?
No.
Given that, Your Honor, we would ask that probation's recommendation be adopted, given no additions, deletions, or corrections to the PSI report.
Mr. Varner, is there anything you'd like to tell the court before I impose sentence?
I just want to apologize to everybody. It was it's been a lesson well learned. It was
All right. Sentence of the court that you're placed on 12 months probation. You're to pay $555 fines or I should say court costs and state fees, and $360 probation oversight fees. When can you get that paid, sir?
I need a little bit of time. As you know, I got that other case and I got $1,000 some on that one I'm taking care of right now.
All right, here's what I'm going to do. A payment plan as arranged by probation. I understand what you're telling me on that. So let's work with you and we'll try to get it done.
At this stage, the courtroom pattern becomes unmistakable. Payment plans, probation conditions, behavioral restrictions. It's a system designed to monitor and guide rather than immediately punish. But here's the key difference in this case. The judge explicitly acknowledges the defendant's existing financial obligations. That recognition matters. It shows that the court is not operating in a vacuum. It's aware of external pressures. Still, the responsibility remains. The system doesn't remove obligations, it redistributes them into something manageable. And this raises a bigger issue. How sustainable is this model? If individuals are juggling multiple financial penalties, treatment programs, and probation requirements, the margin for error becomes extremely small. So consider this. Does the system truly rehabilitate, or does it create a cycle where one missed step can undo everything?
I hope they have it all paid within a couple months. So
Okay. So when you talk to probation about how you're going to pay it, they'll set up a payment plan so we can get it paid off. Okay.
sounds good.
All right. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to continue substance abuse recovery program at IHA Recovery. Follow all treatment recommendations with status reports to probation. No assaultive, threatening, or intimidating behavior. You're not to possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. You are to maintain employment with proof to probation. I'll order 365 days in jail. Credit 1. The balance is suspended. All right. Thank you, sir.
Thank you, Your Honor.
Okay. Court calls the case, people. Recalls the case, people versus LaDana Robinson.
Assistant Public Defender Calvin Hawthorne appearing with and on behalf of Ms. Robinson. Ms. Robinson, please state your name.
Ms. Robinson, can you hear me? She's connected to audio? Okay. Oh, Ms. Robinson, can you say something? Okay, that's not working. I see ya. Okay. All right. Okay, Ms. Robinson, I can't hear you. So, whoever that person is helping you, they need to do something else. Hold it. How many people you got helping you? You got, all right. What is that she said? I know you're here. I just can't do anything if I can't hear you. So hold on. I don't read lips either. So Ms. Robinson, what you're going to need to do is probably turn up the microphone. See, her problem is she's trying to do it herself. She needs to get one of those youngsters in the room to do it because she is. She's trying to figure it out. Okay, now they got somebody else. All right. See, whoever that was said, give it to me. Yeah. All right, I'm gonna pass it. She's still working. Well, sooner or later it'll happen. All right, court does call the case of the people versus Micah Martin or Mika Martin.
Teresa Blair on behalf of probation, Your Honor, Ms. Martin was scheduled before the court for a final review hearing on a prosecutor deferred. She did successfully complete all terms ordered by the court, and I waived her appearance from attending today. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with improvement.
This is the outcome every defendant in this courtroom is aiming for, and it finally appears here. Case dismissed. Probation completed. No further penalties. And notice how quickly it happens. No long speech, no dramatic pause, just a clean, efficient conclusion. But don't miss what this actually represents. This isn't luck. This is compliance. Every condition the court imposed, payments, classes, behavior rules, check-ins, was followed through without violation. And in return, the system does exactly what it promised. It clears the record. This moment reveals the full design of the system. It's not purely punitive, it's conditional. If you follow the structure exactly, you can walk away without lasting consequences. Now compare this to earlier defendants. Same courtroom, same judge, completely different outcomes. The difference isn't just the charges, it's execution. So here's the real question. Is the system fair because it offers a path to dismissal? Or is it only fair to those who are able to meet every condition without slipping? Because for many, one mistake is all it takes to lose this opportunity.
Hearing no objection, so ordered. Court does call the case of the people versus Sarah Ostrowski.
Teresa Blair on behalf of probation, Your Honor, Ms. Ostrowski was scheduled before the court for a review hearing on a prosecutor deferred sentence. She did complete all terms ordered by the court, and I waived her appearance from attending today. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with improvement.
Hearing no objection, so ordered. Court does call the case, people versus Rishi Cavallero.
Assistant Public Defender Calvin Hawthorne appearing on behalf of Mr. Cavallaro.
Teresa Blair on behalf of probation, Your Honor, Mr. Cavallaro was scheduled before the court for a review hearing on a prosecutor deferred. He did complete all terms ordered by the court, and I did waive his appearance. Probation's recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with improvement.
No objection.
So ordered. Court does call the case, people versus Anisha Warren.
Silvana Reed, Assistant Public Defender on behalf of Ms. Warren, whose appearance has been waived.
Teresa Blair on behalf of probation, Your Honor, Ms. Warren was scheduled before the court for a final review hearing on a prosecutor deferred. She did complete all terms ordered by the court. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with improvement.
No objection on our part.
So ordered. Thank you. All right, so that's that block except for Ms. Robinson. Did she still? She's not. She logged out. So I'm not going to bench warn her. I'll put her into the next block, Mr. Hawthorne, and let's see if we can get audio. All right.
Okay, I do have her on speakerphone now, but you probably want to see her on video.
Yeah, that's only Ron Brown that does that, and it's a sentencing, so I need her.
I'm
So
trying. I don't know what's going on.
I'm not gonna let you do a Ron Brown on me, Mr. Hawthorne. So let's see if we can get her back on, see if they can get that mic working, and let's see if we can get her sentencing.
Sounds good. I'll let her know. Thank you, Judge.
All right, thank you.
What you've just witnessed is a full spectrum of how the courtroom system operates under Judge Simpson, not through chaos or emotion, but through structured decision-making, layered accountability, and conditional second chances. Across multiple defendants, a clear pattern emerges. The court consistently applies a framework: financial penalties, behavioral restrictions, probation oversight, and compliance timelines. But the outcomes vary sharply depending on one factor: how each individual responds to that structure. Some defendants come prepared, communicate clearly, and follow through. They receive flexibility, structured payment plans, and ultimately opportunities for dismissal. Others struggle with finances, with compliance, or with prior violations, and the system responds with stricter enforcement, including jail time. The most critical takeaway is this: the courtroom isn't just judging past actions, It's evaluating future reliability. Every answer, every commitment, every hesitation contributes to how the judge determines risk versus responsibility, and that raises a broader implication. Is this system truly balanced between accountability and opportunity? Or does it inherently favor those better equipped to navigate it? One thing is certain. Every decision here carries consequences that extend far beyond the courtroom. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.